Hello, everyone. Thanks for joining us this afternoon for this important conversation. I'm going to give a few more minutes for everybody to log on, and then we'll get started. Welcome, everybody. I'm going to give it about 2 more minutes for people to log on. Hello, welcome everybody. I know some people are still joining, but I'll go ahead and get us started. My name is Katie O'Connor, and I'm the Deputy Chief Counsel at Demand Justice. Thank you all for joining us for this important conversation about 303 Creative versus Elenis, a Supreme Court case that was argued yesterday that could have a pretty devastating impact on civil rights laws across the country. I want to start by thanking our partners, Americans United for Separation of Church and State, Lambda Legal, NAACP Legal Defense Fund, and the National Women's Law Center. We're really lucky to be in this fight with you all, and I'm really looking forward to this conversation. I won't waste too much time before getting to the real experts, but I did think it'd be helpful to start with just a brief synopsis of what this case is about. 303 Creative is a Colorado website design company that's owned and run by Lori Smith. Ms. Smith doesn't currently design wedding websites, but she'd like to start doing so. However, she's opposed to same-sex marriage, and she wants to be able to refuse to serve LGBTQ couples. Unfortunately for her, but fortunately for the rest of us, Colorado has an anti-discrimination law that prohibits discrimination in public accommodations on the basis of sexual orientation, in addition to race, religion, and other characteristics. So if Ms. Smith refuses to serve LGBTQ couples, she will violate that law. Ms. Smith filed a lawsuit in federal court 6 years ago to challenge the Colorado anti-discrimination law, claiming that it would violate her free speech rights by forcing her to design websites for LGBTQ couples. And yesterday, her case made it to the Supreme Court. I am thrilled to be joined by 4 super smart people who can really help us break down what happened during those arguments and what it all means. So I'll introduce the panelists really quickly, and then we'll get started. We are joined today by Sunu Chandy. She is the legal director for the National Women's Law Center. Gabby Heibel, Madison Legal Fellow at Americans United for Separation of Church and State. Antonio Ingram, who is Assistant Counsel at the NAACP Legal Defense Fund, and Jenny Pizer, the Chief Legal Officer at Lambda Legal. I do plan on getting to some audience questions at the end of the hour, so if you're in the audience and have a question, please feel free to put it in the chat or in the Q&A function, and we'll try to get to it in a bit. And with that, let's get started. Jenny, my first question is for you. This case feels a little bit like deja vu. In fact, last night I was talking to my partner about having listened to it, and she was like, didn't we already do this? It feels like the Supreme Court has already been asked this question about whether business owners can discriminate against LGBTQ people. And what happened in the cake case and the flowers cake, and how did we end up at this website case?
Yes, well, so Katie, it's great to be part of this conversation, and I really appreciate my fellow panelists here. Looking forward to everybody's views of this situation that we seem to be in as movements trying to achieve and enforce civil rights, so everyone can participate in public life and have opportunities and not face bias and discrimination in the range of public settings, especially since, we have some laws, and the laws are not perfect and they are not complete and they don't exist fully at every level of government, but we do have important laws. And what we're seeing, what this case represents and what the previous cake and flowers cases represent, and also child placing and some of the other issues that this court has been considering in recent times, represents a concerted effort by groups who oppose equality and inclusion to use important constitutional protections for freedom of religion and free speech and other arguments to blow big holes in the essential civil rights framework that our country has had and depended on, that's been so important for the ongoing efforts toward progress that we have in this country. So in the Masterpiece Cake Shop case of a couple of years ago, the small business owner, a baker, made freedom of religion and freedom of speech arguments. He was represented by the same lawyers who brought the case argued yesterday, the Alliance Defending Freedom. That's an organization that has been opposing equality for LGBTQ people for a couple decades now. They started a couple decades ago and have grown to an almost $100 million operation now. And the case that the Supreme Court heard yesterday is one of dozens of cases that they have ongoing, making these arguments in a range of different courts, hoping to get the arguments, the decisions that will give small business owners and others licenses to discriminate, notwithstanding existing non-discrimination laws. So in the Masterpiece Cake Shop case, the Supreme Court, with an interesting set of opinions, ruled in favor of the small business owner on religious liberty grounds, doing a couple of things that we don't usually see in litigation. So the actual decision was based on specific facts in that case, some of which we wouldn't have thought would be important to the outcome of the case, because they were statements made by civil rights enforcers that actually were not material to the decision in the case. But the Supreme Court said the business owner's religious rights were violated. He was treated differently because there seemed to be some hostility expressed in the comments made by some of the civil rights enforcers. And therefore, he should just win. And that's weird for a bunch of reasons, including that usually if there's an error in the process, the case goes back down to look at the issues properly, as opposed to just one side just wins and the folks who had a legal claim just are out of court. So there are a couple of things like that that were strange in the Masterpiece Cake Shop case. What has been important moving forward from that case is, number one, the court addressed the religious freedom claim and said that when we're talking about businesses, religious rights have not given freedom to discriminate. And the court cited in this case about a same-sex couple being denied a cake, the case about racial discrimination by the owners of a chain of barbecue restaurants. And in that case, there was a religious argument that the racial segregation, the refusal to serve African-American guests, was based on a religious belief. And the Supreme Court said, no, you can have your protected beliefs, but you're operating a restaurant subject to the civil rights law. You got to serve everybody without racial discrimination. So it was quite important, we have believed, that Justice Kennedy, in writing for the court in Masterpiece Cake Shop, cited that case, the Piggy Park versus Newman case, said it should apply basically the same way, and that religious liberty rights are important, but they have not in the past. And this was a discussion by the court. It wasn't the holding of the court. We call it dictum, but it seemed to be important guidance that the court was giving, that rule should apply the same way in a case about sexual orientation discrimination by a small business, notwithstanding religious beliefs. So there's some quite good guidance, even though the baker won. Justice Kennedy then went on to sort of tear his clothes and pull his hair and wring his hands, that there are these free speech questions, and they're so difficult, so very difficult, because there can be artistic elements and freedom of expression in certain sorts of goods and services. Very difficult questions, we'll leave them to a future day. Well, yesterday was the future day. And the case that was argued yesterday is one of many in which Alliance Defending Freedom and some of the other self-identified Christian legal groups have argued about wedding-related services that one could see as having some kind of artistic or creative element, such as videographers and photographers and others. And the same argument was made by the florist and some others, sort of putting together religious rights with speech rights, with weddings, and with same-sex couples, as if this is some kind of magic formula that could be distinguished from other sorts of cases. And I think, as the argument yesterday reinforced, well, the small business owners and ADF have not given us some clear principles to draw any of those lines.
Thanks, Jenny. I just saw a question in the chat. The name of the case is 303 Creative versus Elenis, and it was argued yesterday. So Sunu, I'm going to give you the next question. Something that surprised me a little bit about yesterday's oral argument is that the issue of standing didn't come up. But there's a really compelling argument that this case doesn't belong in front of the court at all. I know this isn't the most exciting part of the case, but it seems fundamental. Can you say a little bit about that and why the court perhaps doesn't even need to be hearing the case in the first place?
Sure. Hi, everyone. Sunu Chandy with the National Women's Law Center. Good to be with you all. Well, I think this is the most exciting part of the case, because why is this case even here at this court at this time? And that really comes down to our opponents think they can win. And so when you think about civil rights litigation, you would normally think about, in this scenario, maybe a couple having tried to get this website, you know, this owner, this business to create this website, be turned down, and then file a charge with Colorado or bring a lawsuit, and which would work its way up to the courts. That's what you normally think about when you think about civil rights litigation. No, no, no. Right now, this business has gone on the offense to say, I don't even really do wedding websites now, but I want to, and I want to turn away same-sex couples. That's what this case is about. So there's 100 questions that are open about, will that happen? Did that happen? What happened? What were the facts? And we have all these hypotheticals going on during the argument because we have no facts. Because she didn't even start this website wedding part of her case, of her company yet. And so the bottom line is ADF and groups like that are bringing this forward at this time because they think they can win. And, you know, you can go through the standing analysis, and it was funny because it didn't come up very much, but the first question in the argument was Justice Thomas saying, you know, is this ripe? And there, you know, Ms. Wagner says, this is a pre-enforcement challenge, and, you know, essentially because she's wants to do this wedding website piece of her company, and Colorado has been so aggressive about enforcing civil rights that, of course, if she did that, they would swoop down and, you know, cruelly take her on. I mean, that's basically the analysis. And it's very different than how you would normally think about standing and ripeness and all of these legal theories, because there's actually no problem yet, right? She hasn't yet turned someone down. And question, if they did turn someone down, would we even go to the Supreme Court right now to take this on, right? You know, you have Colorado opposing search because of this very thing. It hasn't happened yet. There's many unknowns. We don't know what will happen. Let it play out. So instead, you have no facts, you have no record, and we have 100 hypotheticals about why this business thinks they can refuse a service to LGBTQ couples. And so that's basically the background a little bit on the posture and, you know, why we're here now and why we shouldn't be here now, but now we've had the cases at the Supreme Court.
Thank you. Very frustrating, but thank you for the answer. Antonio, the amicus brief you filed in the case relies pretty heavily on another case from 1968 that Jenny mentioned, Newman versus Piggy Park. And your brief argues that the opinion in that case is essentially determinative for the present case. Can you tell us what Piggy Park was about and why it should dictate that the petitioner, Ms. Smith, should lose this case?
The Piggy Park case is really interesting because there's a lot of parallels between the case we heard yesterday and the case from 1968 when the court heard Piggy Park. In Piggy Park, there was a white South Carolinian barbecue restaurant owner who, in the wake of the Civil Rights Act of 1964 and Title II, which requires non-discrimination and public accommodations, that he felt there was a religious mandate he had to follow that prevented him from serving Black and white patrons at his restaurant. The Supreme Court, upon hearing those arguments, said, no, you have to follow our non-discrimination principles in this country. And what's particularly interesting is that yesterday during the oral argument, one of the points the petitioner made was, well, this is not actually similar to those sort of cases because we're not wholesale rejecting queer patrons from our wedding website. We're only rejecting patrons who want gay wedding websites. And we'll be happy to make a website about, I don't know, a birthday party for a queer person or a queer couple. And so there's sort of this argument that this piecemeal acceptance of services evades the public accommodation principles that Piggy Park enshrines. But what's wonderful about the Piggy Park case is that there's a similar attempt during that case as well. The white proprietor of the barbecue shop said, well, I will serve Black people at the takeout window because that doesn't impede sort of the racial mixing that I want to prevent. And the court, in that case, as I just previously stated, found that was insufficient. And so I think insofar that even the petitioner's arguments about their partial attempt to serve queer people under our current jurisprudence should still be outcome determinative as not being consistent with 50 years of precedent that stems from, cases and laws that were designed to help create the social cohesion that our country is working towards today.
Thanks. Gabby, one of the ways in which Lori Smith and the justices who seem to be sympathetic to her case seem to distinguish the present case from Piggy Park is by couching her refusal to serve same-sex couples in terms of free speech rather than freedom of religion. Can you talk about that a bit?
Yeah, absolutely. And great to be here. I think, yes, she does try and couch it as being two separate things, but I think I don't think anyone could really say with a straight face that Piggy Park would come out differently if the argument had been based in free speech rather than freedom of religion. We've seen the other side trying to make that argument for several decades. And in the 80s and 90s, everyone thought it was silly. Everyone thought it was ridiculous. But they kept trying, and eventually they gained enough momentum to the point where here we are. We have multiple members of the Supreme Court who appear poised to adopt it. And so I think it's really frightening that, an argument that was seen as patently frivolous in 1968 is now about to be accepted. And I think one of the scary things about this case, I think there's a lot that's really scary about it, but I think one of them is the way that if the court says, free speech allows this opt-out for public accommodations, then that free speech argument can blow a huge hole in all sorts of civil rights laws. So if we take Title VII, for example, as one example, religious employers can make a showing in specific circumstances that allow them to opt out of anti-discrimination employment laws if they make the specific showing about religion. But this case sort of opens up the opportunity for employers to make a free speech argument, which just creates an even broader opt-out for employers. And that means that, for example, an employer could say, I speak through my employees, the way that they present themselves is a version of my speech. And so I'm not going to hire anybody who has a visible disability. we don't see that argument being made quite yet, but I think that this case sort of opens up the opportunity for that doctrinal move to be made in the next few years, couple decades, who knows? But I think that that's coming, and I think it's really frightening that we've moved so quickly in such a terrible direction.
Jenny, a lot of the oral argument yesterday focused on whether making a website is equivalent to speech or whether it's equivalent to conduct. Can you talk about that distinction, what it means and why it's important in sort of the First Amendment context?
Yeah, sure. Well, and I think one place that we start is that in past years, we had Supreme Court law that had a clearer distinction between commercial speech and other kinds of speech, religious or political or other kinds of personal speech. And commercial speech had less protection. And there's all sorts of reasons why many of us think that that makes sense. And I think these days, the law has moved more to provide more protection for speech that we would consider to be commercial in ways that makes this case more problematic than it might have otherwise been. So that's one thing. The doctrine has been moving in a direction that's a little problematic. The doctrine has recognized for a long time that free speech is, that people communicate in a range of different ways. So sometimes it's with words, sometimes it is with conduct, and the law has developed to help us know what kind of protection conduct should have. And among the different ways that the courts have done that is to say, well, okay, so it isn't just that a person is engaging in conduct that they believe conveys an idea. There's some well-recognized cases like wearing an armband. If wearing an armband has been recognized to represent disagreement with a war, or burning a draft card, or other sorts of conduct where there's a general understanding, that there can be a picket line. Sometimes there are signs with words, and sometimes there are people marching. Does the conduct express an idea that reasonable third parties, reasonable people who are present, would understand what the idea is that is being communicated? The law has distinguished to sort of say, well, it's not just that you're engaging in conduct and in your mind, you have an idea of what that means. If it's not actually communicating to other people, then we don't recognize it as protected expressive conduct. And also, do you have other ways of communicating your idea? So one of the precedents that we have thought is important in this area, had to do with whether law schools could be compelled to participate in the military, facilitating recruitment of law students by various kinds of communication and making space available within the law school premises, using the law school facilities, including facilities of communication. And the Supreme Court said, well, you have other ways. Law school, you're very good at communicating. You're all about communicating. You can communicate in other ways. So I think one of the questions in this case is whether this business activity is communication. If so, whose communication is it? To the extent that it's kind of obvious that it's the customer's communication, but the business says, well, it's my communication too. I believe it's my communication. Well, the court should be asking, well, do you have other ways to communicate? You can post signs, you can write a letter to op-ed. Gosh golly, we still have Twitter. You could use Twitter if you like. Would third parties understand that website to be communicating your message or the message of the couple, who, by the way, they're the ones inviting, the web designer is not going to be at the wedding. As Gabby said, I think among the things that's particularly dangerous about this case is the business owner's argument that there's an implicit, from her perspective, an implicit endorsement of the customer if she provides this communicative service. Now, that argument is very similar to the complicity argument made in the cake case by the baker, that making the cake is an implicit endorsement of the couple that's getting married. And the complicity argument has a particular resonance in religious doctrine. It didn't used to be recognized in our religious liberty jurisprudence. In the free speech area, it's more this argument of implicit endorsement. That's not the way the law has operated in the past. And if the court accepts it in this case, the consequences can be very broad, as Gabby said, across employment or housing or education, any context in which there's a civil rights law, this argument could be made. And the consequences could be really serious. We're not just talking about cakes and flowers and websites. We're really talking about all the goods and services that people sometimes really need in a crisis that could be refused if this kind of argument is accepted.
Yeah. We're going to get to sort of the harms that are actually caused by people being turned away from businesses and public accommodations. And I'm going to start with Antonio. One argument that she makes here, Ms. Smith makes here, and that we've heard in other sort of iterations of this case is that, well, LGBTQ people can simply go elsewhere to get a website or a cake or a tattoo or whatever. Your brief makes a really compelling case for why that argument fails, because of the dignitary harms such discrimination can cause. Can you talk about those dignitary harms, what that means?
The dignitary harms that the court has recognized that occurs with sort of denials like the ones that the petitioner is requesting, I think is really elucidated by looking at the intersectionality of these issues. As you know, the queer community is very diverse, and there are Black queer people, Latinx queer people, and Indigenous queer people. And the notion that minority communities who already face all of the sort of structural inequalities and daily discrimination now have to be exposed to sort of bias and maltreatment on the basis of their orientation without legal protection is what this case will lead to. The notion that a Black person who is queer would have less rights to our marketplace than a straight or cisgender Black person is the implications of this case. And I think as Jenny was talking about sort of the impact of this case, it was Lambda Legal a few years ago who litigated a case in Mississippi where there was a queer couple and one of the people in the relationship passed away, and a local mortuary would not take the body because this person was queer. And they had to drive over 90 miles to find a different mortuary. So the fact that someone who's in a process of mourning the loss of their partner is now being told they are, less than human. And I think even the language that gets talked about yesterday during the oral argument at the Supreme Court, the petitioner's counsel kept referring to gay marriages as false marriages. And just the notion that there is a group of people in our secular democracy whose ideals of self-worth should be attacked because of religious belief. It just really shows that we cannot have a multiracial democracy that's inclusive of all sort of gender and sexual identities if we have denials of goods and services based on protected classes.
Thanks, Antonio. There were definitely some real doozies listening to that oral argument. I definitely needed a nap afterwards. Sunu, your brief in the case talks about the economic harms that discrimination in public accommodations can cause. And in particular, it discusses the discrimination that women have historically faced in public accommodations and how that discrimination has deprived them of what in your brief you call non-tangible goods and privileges, like leadership skills, business contacts, and employment promotions. Can you say a little bit about that?
Sure. A couple of things I wanted to add on, and Antonio said it so well, but at the end of the day, this analysis is not limited to LGBTQ individuals. The way this First Amendment analysis works is that if you go down this road, this will be a way for businesses to turn away anyone who they don't agree with. And so that's why you had this parade of hypotheticals yesterday about Black people, about disabled people, about women, and all the different ways that businesses can say, well, if I do your business card, it's going to really, announce to the world that I think you should be the head of your company. And I don't actually think women should be leaders. or any number of hypotheticals. Yeah, and most of them were not addressed by counsel, for ADF. She just sort of let them lay there. I wanted to also pick up on Jenny's point about this implicit information. And I thought Justice Jackson was really in a problem-solving mode about, if you're worried about this, like, why don't you just put a little line at the bottom just saying, like, I believe marriage is between a man and woman. Like, you can put something on there that announces to the world that you, website designer, which PS, nobody cares about you. It's not your story, as Justice Sotomayor said. Like, anyone who's created these websites, like, they're very hard to do in terms of the user. And I don't even know which company I used, right? It was just like, we did all the work. And the thing that really was fascinating to me is it felt like the other side was flip-flopping about, can we give you a sort of set up standard thing if I'm not creating it for a same-sex couple? Is that okay or not? And I think that flip-flopped a few times during the argument, which made it really confusing, because Justice Gorsuch was like, no, this is about custom. We're talking about custom here. And and Ms. Wagner was like, no, because even if we give you just the thing that's already made, it's going to announce to the world that, like, we're for your gay wedding. And A, that's not true. And B, as Justice Jackson said, you can find another way to say, I'm not into that, but they paid this $100 and I let them use this thing. So it's not really about that. And if it was about that, there would be any number of ways to address it. And I do think the justices will find, some way to find some pathway. And, that's what I was so stunned about, is the ADF attorney was so extreme that, like, in comparison, the justices all seem like, okay, well, we're just trying to find some middle ground about what speech is. And that was the other thing. There was almost sort of, was it Alito or Kavanaugh saying, like, well, it wouldn't be cakes, like, that's not speech. And it's like, oh, really? Okay, we just had a whole case about how cake was speech and how photography was speech. Now we're saying this is, like, closer to speech. But I don't know. I found the whole thing interesting. But the bottom line was, anything that comes out of this case will be used against people of color, queer or not, women, disabled people, and any group that's protected by civil rights laws under public accommodation. Because once you go down this road, as Gabby said, I didn't even think about the employment context, about, all these other contexts where entities can say, well, if you do that, it's going to announce to the world that I agree with that. And so I don't need to hire you, or I don't need to, sell you this service. So, we really cannot emphasize enough how much is at stake with this case. I do want to give a shout out to Covington and Burling. They worked with us on our amicus brief, and we represented a group of 35 entities who all came forward to say this cannot be. And so I do think there's a very strong coalition, as evidenced by this group here, that we are all together saying, we've had decades and decades of civil rights laws and protections, and we cannot just sweep them away. That is not the direction we're going in. And so that's like my only bright spot, is that we're all sort of here saying that, raising the alarm. And I also need to say, like, I don't think I heard dignity once. As a queer person listening to this yesterday, it's like to listen to 3 hours on, like, you and your wife might be able to be, like, turned away from any number of businesses, right? And to listen to the, like, KKK t-shirts, and to, like, not have the question about disabled people taken up really seriously. Like, any number of ways, like, this was not a pleasant experience to listen to this argument. And this is where we are, which goes back to my first point. Our opponents think they have an audience here, and they can change and roll back our decades of progress. And so at this point, we're looking for that narrow loss where it just, like, chips away a little bit instead of a lot, because that's the land we're in. And I just feel like I need to name that.
Yeah, I really appreciate that. And going back to Antonio's comment about some of the language that was used in the case, I felt like some of the language very clearly indicated to me that, like, they believe they have an audience with the conservative justices, and many of the conservative justices feel the same. Gabby, I'm going to stick with this topic of like the harms that these laws really, or that discrimination and public accommodations really cause for a few more minutes. So your brief in the case goes into a lot of detail about how a ruling in favor of Ms. Smith, which she would characterize as a win for religious liberty, could actually be so harmful to many religious minorities. How so?
Yeah, I want to start by just echoing what Sunu was saying about how unsettling it is to not hear any discussion of dignity. And I think, especially, I'm about to start talking about the harm done to religious minorities, but I also think it's important to sort of sit with the harm that's happening to LGBTQ folks immediately right now with this case and every single day in our country. But at the same time, I think we also simultaneously need to be thinking about how this case will open up harm for so many other groups. Because like we said earlier, public accommodation laws protect against discrimination based on race, gender, sexual orientation, disability, a whole bunch of other factors, and religion. And so if the court says, yes, Ms. Smith can discriminate against gay customers, then there's nothing stopping another business from discriminating against Muslims or Catholics or Sikhs or any other religious minority. And so the brief that we signed on to tried to highlight that and give a lot of examples of how this will harm religious minorities all across the country. So one of the examples that we can think about is rather than maybe a website designer, instead an event organizer who says, I will organize any event, but I will not organize bar mitzvahs or bat mitzvahs. I don't think anybody would question that event organizer is discriminating based on religion and is being anti-Semitic. And I think one of the ways that example is helpful is in responding to Ms. Smith's argument that, oh no, I'm not discriminating against gay people. I'll serve them in all these other contexts. I just won't serve them when they're seeking a wedding website. I think she got a lot of mileage out of that argument before the Supreme Court, but it really doesn't hold up in the context that she was arguing it, and it doesn't hold up in any other context as well. And so I think that's one of the things that the brief that we signed on to was trying to show was, no, this is also discrimination against LGBTQ people, just like it's discrimination against Jewish people if you refuse to serve them at a bar mitzvah. And I think it's discrimination against religious minorities is frightening and upsetting no matter what. But I think right now, especially when we're seeing this rise in anti-Semitism, in violence and hate speech against religious minorities, it's just even more frightening to hear this case right now in our current context. And so none of that is to detract from the harm that is happening to LGBTQ folks with this case, just to highlight that this affects all of us. All of us benefit from public accommodations laws, and all of us have something to lose right now.
Yeah, thank you. Jenny, after the Dobbs decision earlier this year, in which the court overturned Roe versus Wade, a lot of people started to worry about other constitutional rights that have been protected under the same sort of umbrella of privacy rights framework that used to protect the right to abortion. One of those rights, of course, is the right to marry the person of one's choosing, regardless of sexual orientation. How might this case that is about protecting LGBTQ people from discrimination foreshadow whether marriage equality is truly safe with the Supreme Court?
Well, I think there's the indirect ways, the signals, the attitude, the tone, and then there are maybe some doctrinal ways. I think we start by recognizing, and many of us have been pretty anxious and stressed, and some wonderful people have been working on passage of the Respect for Marriage Act to mitigate harms, not to codify Obergefell, because we don't necessarily think that Congress has the power to do that, but to mitigate the harms in really important ways, because so many people have been really stressed and anxious about what their family security, given Justice Thomas's kind of gratuitous concurring opinion that, while we're at it, why don't we why don't we erase some more fundamental rights? And, you know, I think many of us did not take much comfort from Justice Alito, including in his majority opinion, oh, this is just about abortion, because he did join the, you know, statement that was issued when the court did not take Kim Davis's case when she was seeking to vindicate her objection to doing her job as county clerk, of issuing marriage licenses. You know, the court said they weren't going to take her case and she would have to accept the punishment that she was given for abusing her government office. But Justices Thomas and Alito issued a statement saying, you know, we agree this isn't the right case, but gosh golly, we sure would like people to bring us some cases so that we could reconsider Obergefell, because we really disagree with it. Kind of an extraordinary thing for any federal judges to be doing. And, you know, Alito joined that. And so sort of saying the way he approached Dobbs and the reasoning that, or I use the word reasoning loosely there, you know, would only be relevant with respect to reproductive health access and abortion, nothing else, because he's already expressed his desire to look at other issues. And the approach used in that case, I think, causes us real concern for multiple reasons, including the bizarre cherry picking of history to justify elimination of rights, and the selective focus on certain rights recognized as fundamental privacy rights, as if parental rights with respect to other issues, or, you know, I think many of us have noted, well, it wasn't just about same-sex couples marrying, it's also about interracial couples marrying. There's no principles here that would allow elimination of certain fundamental rights and not others, unless we're going to have an area of law that really is just raw exercise of power on issues that particular justices have strong views about. That's a pretty terrifying picture from the Supreme Court. In terms of this case, I think some of the things for us to watch and see what the court does are the repeated references to the language in Obergefell that Kennedy included toward the end. This, what seems to have been an attempt to say more generally, can't we all just get along? You know, we're issuing a decision here that some people aren't going to like, but decent and honorable people can disagree about marriage, marriage for same-sex couples or marriage more broadly. But that language has sort of done the opposite of calming the waters. I think it's been taken as an invitation by those who disagree with marriage equality. Keep on working on it. You've got some receptive ears here at the court, and Justice Alito's questions yesterday in particular, probing, well, you know, to Colorado Council, do you think that Justice Kennedy thought that racists were decent and honorable? Sort of trying to make the point that, well, there's different kinds of discrimination. Some of it's decent and honorable. The anti-gay discrimination, good people do that, but of course, good people are not racist. The law has not created a hierarchy of state interests in this area. And that is among the things that I think, if the court were to go down that path and selectively point to certain important parts of our history to say the state interest in eradicating race discrimination is very important. We recognize case law saying that, but we're going to treat other types of discrimination differently. And if not hold, possibly start paving a path to say that the state interest in enforcing civil rights laws is lesser with respect to other types of discrimination. And maybe it would be specifically about same-sex couples, maybe LGBTIQ people as a group, but maybe also the other types of discrimination, creating both a confusing and a divisive, and as Antonio said so beautifully, you know, human beings are complex. We're made up of lots of personal traits, and we're going to have a type of law in which civil rights law could protect a person if you could show that what was really going on was the race element of that person, but not the sexual orientation or the religion or the sex of the person. I'm quite worried about whether the court will go down that path. You know, I think the other thing that is concerning here is that this was a case about wedding related services. And we've seen this string of cases about wedding related services, presumably because Alliance Defending Freedom and the others have an argument that they think it's special and the law should treat it as special. But, you know, we've had cases about a range of other contexts where religion was invoked as a reason for discrimination. You know, if we talk about lodging, where we had a lesbian couple that was refused lodging at a bed and breakfast in Hawaii, would it be treated differently if instead of it simply being a vacation or an attempt to visit friends in Honolulu, it was their honeymoon? You know, what about restaurant meals? You're going to get ejected from the restaurant if you're there to celebrate, if the owner discovers that you're celebrating your wedding anniversary as opposed to a birthday. And as Justice Jackson showed, there can be Christmas can be quite special to various people, and for other people it's secular. So what about the Santa at the shopping mall? I mean, I think the hypotheticals that were tossed around were really offensive, but she was getting at the reality that lots of different things are considered special in different religions and also, you know, to individuals. So if we're going to start creating exceptions to civil rights laws because business owners think that something is special, then customers are not going to have much protection left. And, you know, all of those reasons add to our concern about what this court might do about marriage in a future case where that issue might be presented.
Thank you. Antonio, I'm wondering if you can just walk us through the potential outcomes, the possible outcomes of this case. Obviously, there are ways that the court could go big or perhaps go small. Can you just kind of outline those for us?
I think it's important to remember that even though this case has a religious context, that is not what this case is about. It is about a First Amendment carve out to discrimination law. And so there could be a broad ruling where if someone has a belief that they feel is infringed through providing a service that implicates, you know, public accommodations, the court may rule in their favor. And I think it's important to sort of bring up a hypo that occurred yesterday during the oral argument, where I believe it was Justice Gorsuch who said, well, the petitioner also wouldn't serve a heterosexual couple who were married after both having previous relationships that were legally recognized, divorcees remarrying, or even a couple who sort of refer to their relationship as a non-traditional cis, even though they're cisgender heterosexuals. And so the notion that this type of discrimination could impact anyone who a person may disagree with. There's a ruling that could justify that sort of broad sweeping discrimination. And the other side of that sort of spectrum is sort of what happened in the Masterpiece Cake Shop, where there was a very narrow holding. And I think a lot of advocates, including Justice Ketanji Brown Jackson, began to get at yesterday. There were a few times in which she sort of proposed a narrow holding to her colleagues on the bench. And so the hope is that there will be a holding that will likely be in favor of the petitioner, but in a way that does not sort of open up this Pandora box that would allow discrimination on any number of backgrounds that right now is impermissible.
And this is a related question for Gabby. So if the court allows Lori Smith to deny services to LGBTQ people because providing them would violate her free speech rights, will it matter that her objection is based on her religion? Or would a ruling for her in this case allow people to assert objections on all kinds of bases, like religious or moral or just completely arbitrary to providing services to people?
I think it's a bit hard to say at this point until we have the opinion. And I think Antonio's answer sort of highlights the different ways that that opinion could go and the scope of the consequences. But I do think that this case is sort of just one example of a move that we're really seeing on the other side, and from some justices on the court to say that religious speech gets more protection than any other kind of speech, which is something that the court hasn't done before, but we're seeing it more and more. And to give an example of maybe a more sympathetic plaintiff, if we imagine a coach who kneels midfield at the beginning of football games to protest police brutality, then under this sort of new approach where religious speech gets heightened protection over other sorts of speech, then that coach would get more protection if he said, I'm kneeling because I believe that racism and violence is sinful, versus if he said, I'm kneeling because I'm worried about the safety of my own players. And that doesn't really make any sense for one version of the same message to get more protection just because it's religiously motivated. And that's something that the court has rejected. The court has said over and over, we're not going to give certain speech more protection over other sorts of speech. There are, of course, some exceptions to that, but the court has been pretty consistent in saying religious speech doesn't get more protection than, say, political speech. And we're seeing a shift in that. We're seeing the court being more willing to go down that road. The Justice Gorsuch's discussion about like sort of doubly protected speech from the Kennedy case this summer is just sort of one example of that, and hard to say where that's going, but it is one of the many things about this case that's a little bit nervous making. It creates this kind of double-edged sword of, you know, like we were saying earlier, it's not great if there's a new free speech opt-out in addition to a religious opt-out, but it's also not great if religious speech and religiously motivated activities get more protection than any other sorts of activities.
Thanks. So Sunu, I'm going to go to you next. And I did want to ask if the court rules for Lori Smith in this case, where do we expect it to go, and how far is this line of cases likely to go? Where will it end? But we have an audience question that I think is somewhat relevant. When you have 5 or 6 justices who are, you know, arguably very activist, it's hard to imagine changing their minds because they don't even need to act as a block. They can afford to lose 1 or even 2 justices sometimes. So what are the approaches that we as sort of everyday Americans can take to pressure change in the Supreme Court?
Right. These are the questions we're grappling with, but I think, you know, litigation and civil rights cases are just one way that we do culture change work. And I think we have to keep in mind that we are all working to change society and for the good of society. And that's going to take many, many different strategies. And in bringing and defending these cases, we are telling the stories of the people who are impacted, and that can also help to change hearts and minds, and also help to have, you know, even better laws that are passed in Congress. As Jenny mentioned, the Respect for Marriage Act is definitely a defensive move, but also had bipartisan support, and so really shows that our culture is sort of becoming more and more tolerant. And so we're hoping that our laws at the same time are not chipped away. I wanted to just add on to what Antonio said about possible outcomes. I think it could be, you know, a line could be drawn about if a service is more custom versus off the shelf. I think that is one way it could go. I think another way we could lose that it could be focused on, this is about the view and not just the person. I think Justice Barrett and also Justice Gorsuch were going down that road. If you have straight people with sort of more progressive views, they can be turned away too. So it's not really about the person. It could also be around what is speech, and it could be a wedding website. You can turn people away, but not for the cake or not for the catering. And, you know, it's interesting, just as Thomas said, well, this is like a riverboat. And it's like, are you trying to limit what counts as a public accommodation? Like, I didn't know where that comment was going. But I do think that, you know, as Antonio said, that there was work that was being done by, I think, Justice Sotomayor and Kagan and Jackson to sort of create some relatively reasonable line when it comes to this. But the other thing I wanted to name that really was offensive was Justice Gorsuch talking about the business owner in Masterpiece having to do training as part of that, and sort of being like, and you had to go and re-educate. It's like, you're talking about a baseline civil rights training. And it's like, if that is the hostility given for that kind of a thing, it just sort of spoke volumes to me about where we are in terms of, who is seen as the victim here. And at the end of the argument, when the attorney for ADF talked about the cruelty to the business owners, when dignity wasn't mentioned once, when it came to the actual people who are harmed, if these civil rights laws are chipped away, and to talk about the love of neighbor. I mean, it was just gaslighting start to finish in terms of just the kinds of words that were used. And so I say all that to say, we cannot, those of us who are trained as lawyers and are in this work, we cannot abandon the Supreme Court, but I think there are many conversations going on, in light of the leaked opinions, what is the integrity of this court? And is this court going to be accountable to all of us in this country? And if not, what are the moves we can make to try to push for that? So I think these conversations are ongoing. Obviously, voting today, I don't need to mention that again, in Georgia and everywhere is so crucial, because that's how we gain the power to sort of have leaders who can put people who are aligned with our civil rights history and laws and in favor of them.
Thank you. Yes. Sorry, I was just going to say, Justice Gorsuch characterizing, training on how to comply with the law as re-education was startling, and just goes back to, Antonio's earlier point about the language that was used in this oral argument that was confusing and alarming, and at times really untethered from what the case is actually about. Sorry, I interrupted you, Jenny.
Yeah, no, it's okay. I just wanted to add to what Sunu was saying, and it responds somewhat to one of the questions that that was posed about what might we do, and of course telling our stories, amplifying our stories. Some of us, not me, but Sunu, for example, is a published poet, so there are different ways that we affect culture, and that is those conversations are essential, because where we're aiming is for people to treat each other differently, not just because a court or a legislature or somebody required it, but because people actually want to treat each other in a better way. Some of us litigate and some of us draft bills and statutes, but what we actually want is for people to behave in a different way. So I do think that that last comment, and Sunu, I used the same term, gaslighting. Kristen Wagoner, when in her closing, talks about love thy neighbor and whatever, and she's talking about a concerted campaign by her organization to dismantle civil rights laws in the name of religious liberty. That's not what I mean by the term love, or treating my neighbor in a loving and embracing way. So among the things on the table are the Equality Act, so I mentioned the Respect for Marriage Act, and that could be an important mitigation of harms, but we only have laws like Colorado's in less than half the states at this point, and some municipalities and states that don't have a state level law. And we do need that protection at the federal level. It's a little, I don't know, odd, but nonetheless important to talk about the need for comprehensive protection at the federal level, including broadening the existing federal public accommodations law, because as of today, it doesn't even cover retail businesses, like this website designer person. And so that protection needs to be broader to deal with the range of types of systemic discrimination that persist, as well as to be inclusive of LGBTQ people, and to prevent sex discrimination more broadly. And it's a little odd to be talking about the need for that protection in the context of a case that's about making those protections much less effective. I think we just need to keep these ideas a couple of ideas in our head at the same time, that we have to keep working to make the protections more effective. We also need to continue to work within employment and other settings, voluntary policies put in place by whether it's employers or others who are running institutions that bring together a bunch of different people. Those are really important too. And okay, so Justice Gorsuch wants to talk about basic diversity training or education about what the law requires as re-education, with the references to, heaven knows what. We need to maintain the conversation that people will do a better job of following the rules and treating each other better if they have a clearer, better understanding of what's expected of them. What counts as harassment? What protection do you get for your religion? You get some accommodation under current law, and rightly so, but the accommodations shouldn't be at other people's expense. If people can understand better how these responsibilities relate to each other, then we can call people to treat each other better. In my experience, business owners of various kinds, including doctors, have had, I think, sometimes sincere beliefs that their religious rights include the right to ignore the law if they have a religious objection. And in a case that I litigated for almost a decade, ADF was on the other side supporting that kind of argument, and they lost unanimously in the California Supreme Court. California Supreme Court is very different than the current makeup of the US Supreme Court. And if the Supreme Court expands free speech rights and or religious rights in ways that make our civil rights laws in some contexts unenforceable, then the statutes and the ordinances are a lot less helpful. And it does take us to one of the other questions that's been posed in the Q&A about court reform and the range of different things that might include. And I just think, obviously, Demand Justice is doing a lot of leadership in that, and lots of other people are working on it, Lambda Legal, and some of our colleagues in our sibling groups have come out in favor of court reform. There's lots of different ways to think about what might be done. So it seems to me we need to be looking at that, but we also need to be amplifying the public conversation, because I don't think all of the very conservative members of this Supreme Court want to be as out of step with the American people as they currently are. A couple of them clearly don't care and revel in the role that they're in. But I don't think that all of them feel that way. And so, as has been said, we need to keep doing the litigation work that we do, but doing all the other work as well. One last thought on this. Rejection of LGBTIQ people can be among the most profound losses for parents and grandparents who reject their own kids or grandkids or other people in their lives. Those losses are profound. The pain of those losses can be immeasurable. And I think as we do our work to show that the justifications for mistreating trans and non-binary people, for example, that's based on a bunch of made up nonsense. When we tell the truth and people speak in their own voice about who they really are, step by step, we dispel those falsehoods. We did it about same-sex couples raising kids, and we have to do it now about trans and non-binary folks who are being attacked with a lot of falsehoods. And we need to do it really urgently, because the attacks are happening, as we know, with physical danger as well as the range of other impacts. So we really just have to do the work with all the vigor that we can and get to the other side of the lies that are being told today.
Thank you so much, Jenny. I don't think anybody could have said it better. And we are over time, so I think that's a perfect place to end. I want to thank all of you, Gabby, Jenny, Antonio, and Sunu, for participating, and your organizations for partnering. Thanks to everybody who called in for this. I wish you all a good rest of the week, and take care of yourselves.
Thank you.